Digital Personal Data Protection or the DPDP Act is the top trending legal and tech topic in India right now because 2026 is officially the year of enforcement. While the act was passed in 2023, it has moved from a theoretical policy to a high stakes reality for businesses and citizens alike. Here is why it is currently dominating the headlines. Here is the current landscape of AI liability. Number one, the human in the loop. Rule courts worldwide, including the Supreme Court of India, March 2026, have recently ruled that AI cannot be a scapegoat for human professional errors. The case example for this is the Gumadi Usha Rani versus Sure Mallikarjun Rao. The SC declared that a judge or a lawyer using AI-generated fake judgments is not just making a mistake but is committing judicial misconduct. The rule is that if you use AI for professional work like legal, medical, or financial, you are liable for its hallucinations. The second is product liability versus user liability. Liability is now tiered depending on your role in the AI value chain. AI developers or providers are liable if the model is inherently unsafe. For example, if it wasn't trained on diverse data and consistently produces discriminatory results like bias in hiring algorithms. Businesses or deployers are liable for how they use the tool. If a bank uses an AI for loan approvals and it breaks privacy laws, the bank is liable even if they didn't build the AI. Now we come to liability under the DPDP Act in India. While the DPDP Act doesn't mention AI by name, it creates liability through data usage. Consent liability is if an AI model is trained on your personal data without a legitimate use or your explicit consent, the company faces penalties of up to rupees 250 crores. Then we have the accuracy liability. Under Section 8, subsection 3, the companies must ensure that the data is accurate. If an AI uses outdated or wrong data to make a decision about you, like denying insurance, the company is legally liable for that inaccuracy. Liability regarding deepfakes and impersonation. New laws in 2026, like the Digital Dignity Act and the various Indian IT amendments, have made creating or distributing non-consensual AI replicas a criminal offense. The safe harbor principles state that the social media platforms now have only 2 to 3 hours to remove AI-generated deepfakes once reported. If they fail, they lose their safe harbor protection and become legally liable for the content as if they created it themselves. The EU AI Act is a global gold standard. If you operate globally, the EU AI Act, which will be fully enforced in August 2026, categorizes AI by risk. These are categorized under two types of risks. Number one, unacceptable risk, in which the social scoring or manipulative AI is banned. Using these carries fines of up to 35 million euros or 7% of global turnover. The second is the high risk, like AI in education, healthcare, or law enforcement, requires strict documentation and human oversight. Failure to provide these makes the developer liable for any harm caused. Now, let us look into issues: who is liable and what are the legal consequences. Now, if the issue is hallucination or fake information, then the user, the lawyer or the doctor, etc. is liable. The legal consequences is misconduct, professional negligence. If the issue is data privacy breach, then the data fiduciary or the company is liable, and the legal consequences is fines of up to 250 crores, which is mentioned in the DPDP Act. If the issue is algorithmic bias, then the developer or the provider is liable, and the legal consequences civil lawsuits and discriminatory claims. If the issue is deep fakes, then the creator and the platform is liable, and the legal consequences criminal prosecution and the loss of safe harbor. As of 2026, several landmark cases have moved from theoretical risks to concrete judicial rulings. The primary focus of these cases is AI hallucinations, that is fake information, and professional negligence. Here are the most significant cases and legal developments regarding AI liability. The first is the hallucination landmark, which is Gumadi Usha Rani versus Sure Mallikarjun Rao 2025-2026. This is currently the most cited case in India regarding AI in the legal system. Let us look into the incident. A trial court judge in Andhra Pradesh used an AI tool to help draft an order. The AI hallucinated and provided a non-existent case citations which were included in the final judicial order. In the ruling, the High Court held that while the fake citations were a serious oversight, the order would not be set aside if the underlying legal principles were still correct. Ruling on the liability shift, Justice Ravi Nath Tilhari emphasized that actual intelligence must govern the judicial mind. This case established that a human professional, the judge or lawyer, cannot shift the blame to the AI for factual errors. The duty of care remains with the human. The second is the China precedent, the Hangzhou Internet Court case, January 2026. In a global first for developer liability, a Chinese court ruled on whether an AI company is responsible when its chatbot lies. The case is as follows. A user sued an AI developer after the chatbot fabricated a campus for a university and even promised the user 100,000 yuan in compensation if it was wrong. The court ruled that the developer was not automatically liable. Why? The court categorized AI generated content as a service, not a product. It ruled that AI does not have legal personhood and cannot make binding promises. To win, a user must prove the developer was negligent in its duty of care, which is it failed to implement standard safety filters. The third is the AI washing liability, FTC versus Air AI, August 2025. This case set the standard for corporate liability in marketing AI. Let us look at the charge. The charge was the FTC sued a company for claiming that their agentic AI could fully replace human sales teams with 100% accuracy. The outcome was that this established that companies are strictly liable for overstating what their AI can do. If a business markets an AI as human level and it fails, the business faces massive fines for deceptive advertising. The fourth is the Safe Harbor Laws, India's IT Rules Amendment, February 2026. While not a single case, the new February 2026 IT rules have created a new form of liability for platforms like X, Meta, and Google. The 3R liability. If a platform is notified of an AI-generated deepfake or misinformation, they now have a strict 3R window to remove it. The consequence, if they miss this window, they lose their safe harbor protection. This means that they can be sued for the content as if they were the original creators. Now let us look into the type of harm, who is liable, and the landmark rule. If the type of harm is fake facts or hallucination, then the user or the professional is liable. The landmark rule is that human in the loop, you verify or you are liable. If the type of harm is systematic bias or harm, then the developer is liable. The liability depends on duty of care and the risk level. This is the landmark rule. If the type of harm is deep fakes or IP theft, then the platform is liable. And the landmark rule is liable if not removed within 2 to 3 hours. I will be actively pursuing this case in future also. If you liked my video, then please press the like button and hit the bell icon. That way you will get the notifications of all my new videos. And do not forget to subscribe to my channel. Hi, I am Vishwajit and you're watching Landmark Cases.